Associate, and Temiloluwa is a Senior Associate and Team Lead at Farmville Solicitors. He routinely advises various startups on legal and regulatory compliance, as well as data privacy at the often misunderstood intersection of law, tech, and business. Other members of the panel, we have Dr. Patricia Boshe. She is a data protection consultant, a lecturer and a senior researcher at the Research Center for Law and Digitalization at the University of Passau in Germany. And then last but not the least on the panel, we have Mr. Elias Okwara. Mr. Elias Okwara specializes in cybersecurity, data protection, and public policy. He serves on the African Union Task Forces on a cybersecurity strategy for Africa and on the Convention on Cybersecurity and Personal Data Protection, Malabo Convention. His most recent work product includes a successful review and amendments of the Malabo Convention. Adebanke, do we want to have Adavize's brother give the opening speech before we go into the panel presentation?
Thank you. Okay. Oh, okay. We have Adavize's mom has been able to join us this morning, and I will just give me a second to give her access to talk. So. Oh. Okay. Good morning, Ma.
Good morning, please.
Thank you so much for joining us, Ma.
Thank you so much for inviting me to. I'm happy to be in your midst this morning.
Thank you, Ma.
Thank you so much.
Yes, Ma. Would you like to say a few words before we continue?
Yes, thank you so much. I would like to appreciate the Lloyd family. I want to really say a big thank you to the whole family. You people have been so wonderful. You've been so supportive to my family in all ramifications. In fact, I can't begin to mention it. And I wouldn't like to be mentioning names, but you all know yourselves. But I want to sincerely appreciate every one of you that have contributed one way or the other to make this program today a success. I pray that God Almighty will continue to meet every one of you at your point of needs in Jesus' name. And I pray that the joy of the Lord will continue to be everyone's portion in the name of Jesus. And I pray that God will keep us all along together as a family so that we'll continue to share, rub minds together as this. Once again, I want to appreciate everyone in attendance. I want to appreciate the coordinators, the organizers, and people that have sponsored this program. The Lord Almighty continue to bless them and open business opportunities to them. And I wish the Lloyd family long life, prosperity, and success in Jesus' name. Thank you very much.
Thank you so much, Ma. We are glad to have you here. Thank you so much, Ma. I think Omezia is not here yet, so we can just go ahead to take Temiloluwa Dosumu's 10 minutes presentation, if that's okay.
Okay, that's fine.
Okay, good.
Okay, so before we go into the general panel discussion, we're going to give each panel member an opportunity, like a 10-minute window for an opening statement. So we'll start with you, Temiloluwa. Thank you.
All right, good morning. Good morning, everyone. Good day to members of our audience who could be joining from other jurisdictions. I'm Temiloluwa Dosumu. I'm a senior associate at Farmville Solicitors. I'm also the team lead of the technology and privacy team. And it's my pleasure to be on the webinar today in memory of Adavize Alao, um, to talk about some of the most interesting issues, data privacy issues facing us as a continent in terms of the evolution of data protection in Africa, and where we are also headed as a continent in the light of some of the data privacy advancements we've made, looking at the AU data policy framework. I'm happy to be here. So, just to mention a few things to perhaps, whet our appetite alongside other discussants, on the panel. I think for, opening remarks, I would say that data privacy really, is not new to Africa. This is not, the first time that, African countries would, have, some sort of regulation or attempts at ensuring that the privacy rights of their citizens are protected. The starting point for that, would be, to look at, most of the constitutions of, the 55, member countries constituting the African Union. A lot of these countries have, provisions in their constitutions that at least, recognize the right to privacy or protect, communication rights or information rights, really, which, is like an overarching rights under where you now find privacy. So a number of, our constitutions in Africa here, so various countries in Africa have these, provisions that at least recognize, the rights to privacy. And, further to that, a number of principles, directives, not necessarily, laws and acts or legislation, but just, principles began to develop over time in different, African countries. Some of them as far back as 1990 in some of these African countries, so it's not new to us. So after that, we had, some interesting, harmonization, at the, apologies for that, at the AU level, where you had the 2014 Malabo Convention, which, of course, was fraught with a number of issues, which is why we are where we are now, which is the AU data policy framework. So, in a nutshell, we have had a number of attempts at ensuring the rights of Africans, when it comes to privacy. Those rights are properly protected. Governments have tried, at regional and the continental levels. There have been efforts, if you ask me, and those efforts are well documented, and we'll be delving into, alongside my other colleagues on the call, delving into some of these trends and efforts today to land us where we are. And why would we be having this kind of discussion at the time? Now, we're having this kind of discussion at this time because Africa is known for its population, right? There's a whole lot of population, growth and expansion in Africa. And the most important thing about this, which I know will be exciting to us, that more than half of this population, represents youths. So we have a very young population. Now, what that means is that there's a whole lot of, ripe market for, digital, trade and the digital economy to drive. So while you have, the technologically advanced nations in the US, in Europe, and other parts of the world, being able to churn out technology and technological products, the market really that is ripe, that is not yet saturated and has, an increasingly active youth, population is Africa. So you have more young people in Africa, earning, a bigger income as the day goes by. So what this inadvertently leads to is a concomitant growth in internet, penetration. You have more people engaging in mobile payments, transactions, mobile money, like you have, in Kenya with the M-Pesa, and also in places like Nigeria, where we have a whole lot of, e-commerce activity also. So with that, there's a whole lot of need to protect, the citizens and the residents of Africa, because wherever you have an increase in technological growth, or there's an expansion in the digital economy, of a necessity, there must also be the protection of rights. Why protection of rights? Protection of privacy rights, because for every advancement in technology, when you are posting a picture online, where you are ordering a ride sharing or a ride hailing application, a lot of information is requested, personal data or personal information such as your name, your picture, your email address, your phone number. I mean, this constitute information that are private and are personal to you, which when analyzed can basically put you in harm, or want to be able to profile who exactly owns what, who exactly is doing this on the internet. Basically, it's a piece of you, your name, your medical history, your gender. I mean, they are all pieces of you, and they belong to you. They are like your property, really. So every time you're on the internet, every time you're are putting your information somewhere, whether online or offline, I mean, a part of you is being stored in several places, and a part of you is being taken away. So what countries like EU countries are beginning to do is to find, while also attracting revenue, which is very important. I mean, we're also beginning to look in the direction of striking the right balance between opening Africa up to the rest of the world, which is what the AFTA framework has tried to do, but they didn't really do so much in terms of data privacy, which is opening up Africa to the world, but also ensuring that our rights are not breached, that the rights of our people are protected, and that also brings a whole lot of sanity into this space to see that we are not exported. Africa has always been fighting some of the evils of expansion, economic expansion, really, from the time of dumping toxic waste in Africa to slave trade and a number of other issues. Now, the battle that Africa should be fighting is how to ensure that the privacy rights of its citizens are being protected. So that is an interesting conversation for this age, or for this information the digital age that we are in. So how to protect that across the African continent is what we are looking at today, where we are coming from, where we are going to. The existing framework, is it strong enough to ensure that we are a stable and a strong continent in terms of protecting the rights of our growing population, our rights that are not being exploited, and those technologically advanced nations and companies coming into Africa, how well are our rights safeguarded? How well are the rights of data subjects also safeguarded? I mean, I could go on and on, but I think I should have exhausted my 10 minutes now. So this and many more will be on the table for discussion today. Thank you very much. I don't know if I've done justice within 10 minutes.
You have. Thank you so much. Thank you, Tim. Thank you. Next on the panel, we have Mr. Elias Okwara. We can have your presentation now, sir.
Thanks very much, and thanks to Lloyd and Adavize for making this presentation possible in memory of him. Yes, so it's interesting. We were talking about the data protection landscape in Africa, and I come in from the AU side of things, but before I go into that, I just wanted to breeze through some key elements that we have seen across the continent. For example, the most common data subject rights we have seen include the right to access, the right to rectification, the right to object, the right to erasure or the right to be forgotten, the right to information, and then perhaps less common but also prevalent are the right to not to be subjected to automated decision-making, the right to restrict marketing and advertising processing, the right to obtain personal data in an understandable form, and then even less common is the right to portability, the right to submit complaints, the right to obtain compensation from data controllers, and the right to withdraw consent. Now, of course, the other aspect that we can look at across the continent is this legal basis for processing personal data. And what we see is that consent is the most common across about 30 jurisdictions out of the 34 or so countries that have a data protection law. Actually, that would be probably around 31. And then the contract with data subject as a legal basis is also prevalent. The interest of the data subject as a legal basis is also prevalent. The legal obligation as a legal basis is also prevalent. And then, of course, we have public interest and then legitimate interest, which is less common in about 17, 18 jurisdictions in Africa. And what about the legal basis for cross-border transfer? This issue of cross-border transfer is not that talked about in Africa because we have not introduced adequacy mechanisms, although I do understand that the Nigeria regulation has some sort of an adequacy mechanism that even accounts for the Convention on Cybersecurity and Personal Data Protection, also known as the Malabo Convention of the African Union. And I'll talk a bit more about that in subsequent slides. But the legal basis for cross-border transfer, we see that adequate level of data protection is prevalent in 30 jurisdictions. Data subject consent is prevalent in about 24 jurisdictions, contractual obligations in about 23 jurisdictions, public interest in about 16, 17 jurisdictions there, and then legal defense claim also in 16, 17 jurisdictions. And then about 12 jurisdictions have the vital interest for the data subject, and the legitimate interest, we have about 8. And then finally, just to round up my list of facts across the continent of Africa, we have these exceptions to privacy rights. And what we see is that public safety is the most prevalent exception to privacy rights, and it's prevalent in about 23 or so jurisdictions or 22 jurisdictions in Africa, and then followed by national security, which is in 21 jurisdictions, and then less common is law enforcement access to data as an exception to privacy right, and that's prevalent in about 6 jurisdictions. But in any case, let's now talk about this Convention on Cybersecurity and Personal Data Protection, also known as the Malabo Convention. A bit of background, deliberations on cyberspace regulation and data protection have been ongoing since the late 1990s around the world, and the need for drafting a cyberspace regulation for Africa was initiated in 2009. The Extraordinary Conference of African Union Ministers in charge of communication and information technologies meeting in Johannesburg in November 2009 requested the African Union Commission to develop jointly with the United Nations Economic Commission for Africa a convention on cyber based on the continent's needs and which adheres to the legal and regulatory requirements on electronic transactions, cybersecurity, and personal data protection, right? So the interesting thing about this convention is that it covers these 3 things: electronic transactions, cybersecurity, and also cybercrime, and personal data protection. Now, more so the digital transformation strategy for Africa of 2020 to 2030 endorsed at the 36th ordinary session of the African Union Executive Council in February 2020 in Addis Ababa, Ethiopia, also selected cybersecurity and personal data protection as one of the cross-cutting themes for the realization of the African digital transformation. So following the request that was made in 2009, The Malabo Convention was drafted and subsequently adopted in 2014 by the African Union heads of state and government. It aims at promoting effective harmonization of African legal instruments in the area of electronic transactions, personal data protection, cybersecurity, and cybercrime. At present, we have about 14 countries that have ratified the convention, and these countries include Angola, Cape Verde, Congo, Ghana, Guinea, Mauritius, Mozambique, Namibia, Niger, Rwanda, Senegal, Togo, Zambia, and the most recent one to ratify is Gambia. So what this means is that one more ratification is needed for this convention to enter into force pursuant to Article 36 of the convention, which requires ratification by 15 African states for the convention to come into force. So we are on the cusp of having what you might term the African GDPR, although it's actually more related to the EU data directive, which preceded the GDPR and seeks to align with Convention 108 plus of the Council of Europe. Now, when you think about this convention, there are certain strengths and gaps that we identified as part of the work in looking at the promise of data protection and cybersecurity in Africa. And so one strength is that it is broader than similar conventions. It is unified continental approach in terms of cybersecurity and data protection. It encourages member states to recognize the need to protect critical infrastructure, personal data, and to encourage free flow of information through a unified regulatory framework. It will obviously assist African countries in developing guidelines and serve as a model legislation that member states may adopt for cybersecurity and data protection regulation, and also electronic transactions. It encourages multi-stakeholder engagement of governments, criminal justice authorities, private sector, and all actors to work together to effectively and efficiently address the issue of cybercrime and electronic evidence. Some of the gaps that we took note of in the convention include the fact that it merges three interrelated but the separate topics of electronic transactions, personal data protection, and cybersecurity and cybercrime into one legal instrument, right? So there's a bit of that merging is not a common phenomenon that we have seen across the world. Different jurisdictions have specific legislation that are separate addressing these three issues. And then its broader scope is raising the possibility of an overlap with existing national laws, and thus there's the reservation of ratifying the Malabo Convention as it may affect the implementation of already existing national laws. And then there were other gaps that we noticed in the Malabo Convention, and that included there were some definition gaps. So for example, and I'll give you just one example here. For example, in the definition of critical infrastructure, there's reference to critical infrastructure, there's ICT infrastructure, there's critical cyber infrastructure, right? So there's an inconsistency in terms of the definition. And then at the same time, even that definition within the Malabo Convention did not account for public health. There was inconsistent application in the text. And then there were some other elements that were missing in the convention, right? And some of these elements would touch on substantive requirements of the law. So I'll give you some examples that we found missing within the law. So for example, we could not find privacy impact assessment. We could not find privacy by design, for example. We could not find risk-based approaches to compliance and enforcement. There was nothing about educational and student privacy and children's and minors' privacy, etc. And so those are some of the gaps that we identified within the existing framework of the Malabo Convention. So as I wind up, we agreed at the African Union level that the goal was to expedite the ratification and entry into force of the convention, which is spelled out in Article 36 of the convention, that the convention shall enter into force 30 days after the date of receipt by the chairperson of the Commission of the African Union or the 15th instrument of ratification. And then, even as we recognize that there were these gaps, and we even proposed amendments that were approved by the African Union management, it is important to draw attention to provision of Article 37 of the Convention that the Malabo Convention can be revised or amended only after it has entered into force. And that then would lead to a country to sponsor some amendments to the convention so that we can be able to have an updated instrument. Because as you can imagine, the Malabo Convention was agreed upon in 2014. A lot has changed in the world. New technologies have emerged in the world. New legislation have emerged. Countries, national countries in Africa have endorsed and adopted new legislation in data protection and privacy by design. There's been the GDPR, which has set the pace for global enforcement of privacy and data protection. So a lot has changed since the Malabo Convention. So there'll definitely need to be amendments to the convention so that it accounts for changes that have taken place since it was initially agreed upon. And those changes can only be initiated by a state, although the amendments that we provided and the changes that we proposed will then serve as a guide to the African Union member states when they are amending the convention. So essentially what will happen is that once the convention comes into force, then it to be followed by these amendments, and these amendments will already baked into the discussion, so it will be easy for member states to adopt these changes. So the way forward we agreed at the African Union level was that we would pursue the outstanding instrument of ratification from Africa states to allow the Malabo Convention to come into force, and then submit a proposal by any African Union member state who can spearhead the review of the convention based on technicalities or provisions which do not meet expected standards as it is now, and then pursue a multi-stakeholder approach led by Africans for the revision and amendment of the convention. So as we stand, we have just one outstanding ratification instrument, and that outstanding ratification instrument we have targeted by 2023 to have the convention come into force pursuant to the Digital Transformation Strategy High-Level Implementation Plan of the African Union that was released in June of this year. And that's it from me.
Thank you so much, sir. Thank you for your presentation. And may I add that if you have like any questions you want to be discussed or any comments you want to be discussed during the panel session, during the panel discussion, please use the Q&A function and then we'll attend to your questions. So we're supposed to have our third panel member, but unfortunately, she's not on the call. So we'll just move right into the panel discussion. So like I said, if you have questions, please use the Q&A session and then we'll try to attend to your questions. So my first question goes to Temiloluwa. You did mention the the after act opening up the continent to investment and other opportunities, right? The world is becoming like more integrated with the advent of like digital economy in the international space. Like, so right now, without a robust data privacy regime, one would say that Africa stands to lose like billions in revenue and job creations as like external parties, external entities who ought to like set up business in Africa, rather just set up shop somewhere else with like more developed data private data protection laws. Do you think that's because currently, I mean, I believe there's a section which is not very major. There's a section on data protection on the after, which is not very major. Do you think that the agreement should consider like incorporating specific data protection provisions to maintain international best practices in data protection so as we don't lose out on revenue and investments that might come into the continent? Hi, Temiloluwa.
All right, can you hear me?
Okay, did you get my question?
Yes, please.
Okay, thank you.
Thank you very much for your question, and I must also say thank you to Mr. Okwara for opening up very, very interesting technical discussions. Right now, I might want to, take, a kind of stance, on some of the, discussions today. I mean, not for the purpose of being pessimistic, but just to interrogate, some of the progress we have made and see how much, of it translates to actual progress in the real sense of it. I mean, because we may say all we can about policy, but I mean, if the right institutional, and human, capacity framework is not in place, I mean, we are not seeing, agencies, for implementation, where the issue of, resources, for a country, for, a continent like Africa, where, there's even, for education, which, attracts a lot of funding in other jurisdictions, we are still having problems in funding that, I mean, we are a politically, charged, region, you have, some sort of, civil, unrest, at one time or the other, or perhaps on, a periodic basis in most, African nations, and basically all the money goes, there to fighting such, wars, really. So we can say all we want to say about, some of these steps, and, framework, whether the after or the AU data policy framework. But really, at the end of the day, we need to find, that, important balance. First and foremost, I mean, regardless of whatever we say about, the after and, what it does for us, regarding data protection, right? At the end of the day, there's a whole lot of responsibility on member countries. Really, member countries have, a whole lot of responsibilities. I mean, because, I mean, is basically the policy is basically useless if member countries are not committing their will, committing resources, committing personnel, committing funding, committing education and orientation to it. Is more or less useless if you ask me. So I think that's where the discussion for us is really important. I mean, thankfully there's a whole lot of policy on ground to work with, but trade liberalization in the digital economy, first and foremost, while the policy is on ground, there has to be the infrastructure for it. So in terms of infrastructure, we are still lacking. Right, and I think that's something interesting that we should take home. In terms of infrastructure, what is the AU doing, for example, to ensure that conversations are had with, because if you do not have great communication infrastructure, technological infrastructure in your country, which is largely public sector driven, then what privacy rights are you regulating? Where importation of cables, masts, tars, computers, and a number of other things, still have, high taxes charged on them. There's still a lot of, import duty and a whole lot of, restrictions, that are not even acting as a stimulus to some of the infrastructure we need. A whole lot of, technology companies, in Africa, they have, government, running and breathing, running about after them and breathing down their necks with, one sort of tax or the other, one sort of, pseudo registration or compliance requirement that is not even deep anyway. It's just basically, trying to put them into the tax, net and all of that. I mean, if we have all of that, I don't see how, much of a difference, all the policies and protocols after and all of that would make if those conversations are not in place. So what I expect is that, bodies like the AU, hopefully through some of the things that, Mr. Okwara has mentioned, would begin to commit resources to ensure that, high level, discussions are had with member countries to work out, models, to work out, means and approaches to see that, what are you doing, for example, as a country like Nigeria, what are you doing to ensure that, importation of technological infrastructure is highly encouraged? What are you doing to ensure, companies who are, in the telecom space, companies who are in the communication space, they have, a whole lot of, latitude to ensure that they can even grow without, government, breathing down their necks. What are you even doing, regarding infrastructure in that regard? I mean, I think those are questions that every African country should be able to answer. How much of your budget, for example, are you committing to, technology, for example, and how is it spent? I mean, is it going towards recurrent expenditure? Is it going towards capital expenditure? I think those are the important questions that we should be asking, really. Now, in terms of some of these regulations that require applying after, like the protocol on trade on services, after, really, it has started a whole lot of interesting conversations for many countries, if you ask me, in terms of having that harmonized structure within the African continent to ensure that there's a clear direction in terms of policy, in terms of where we are going. Cross-border transfer flow of data between countries is important, but where do the enforcement authorities stand in these different member countries regarding this? I mean, who, for those who are making adequacy decisions, how many adequacy decisions have been submitted to them in the last couple of years where they have enacted their laws, and even under the after, and how many have you approved, for example? So I think until those conversations are had, we cannot continue to go back and forth on the issue of policy, where largely the issue of data privacy and all of that, whether between member countries and whether at the continental level, is largely public sector driven. So if, for example, there is no high level engagement to see how governments of the day are committing themselves to taking out some of these problems. So I'll soon wrap up. I mean, I don't see how much progress we are making, right? Because at the end of the day, you even cross that bridge. You cross the bridge of becoming signatories, to different continental principles and efforts. Some of the major issues still remain, because for a number of African countries, there's that requirement that you must domesticate, some of these laws and all of that for them to apply as your own, as the law of your own country. Now, how many of them have done that? So really, for us to ensure that we do not have a paper tiger on our hands in terms of cross-border sharing on critical data and information to facilitate trade and development in the continent, we must begin to answer some of these questions. We must begin to hold governments accountable. I mean, what is the framework for data privacy practitioners? Because if you have a policy, for example, and there's no conversation between, Mr. Okwara mentioned something about stakeholder engagement. Part of the important stakeholders, we must also begin to harness in terms of their efforts and championing and advocating for these rights with governments, our privacy practitioners. I mean, how many do we even have on the continent? How much is government even committing to their training? I mean, is there any umbrella body under which they could speak and begin to champion some of these rights? I think cooperation in Nigeria, Kenya, and some of the other countries that have made progress in terms of practitioners, privacy practitioners. I mean, we are not there yet, really. So I mean, good step for us. The laws are falling into place after Malabo and the EU data policy framework, but more needs to be done. Thank you.
Thank you so much, Temiloluwa. Thank you for your robust contribution. Thank you. Please, if you don't mind, I would like the panelists to turn on their videos so that at least our listeners can put a face to the name. Thank you. Thank you, sir. So now on to the next question. So I have a question for you, sir, Mr. Elias. So now you did mention, you did talk about the African Union Convention on Cybersecurity. That is the Malabo Convention, which was passed in 2014 and which is yet to be ratified because only 40 member states have signed it out of 55 member states. So now my question is, in the event that this is being ratified, we have the 50 member states and this is being ratified, what are the enforcement mechanism being put in place to ensure that member states comply with this convention, and in the event that they do not, what now happens? How are such states being treated? Thank you. You're muted, sir.
Of course, I had to get that right. Thanks for that question, Poikana. And that's a really interesting question, right? In terms of the enforcement mechanism, how do you address that? So what we've tried to do at the African Union level, remember that this is a convention, so it is a binding legal instrument. So there are mechanisms within the African Union that would see it actually enforced, but then at the same time, we realized that there was this gap, and what we did was we said, let us come up with a Council of Data Protection Authorities that would be housed at the African Union level. And this Council of Data Protection Authorities would be responsible for enforcing the convention, and it will be answerable to the African Union Commission. And in addition to being enforcement mechanisms, the Council of Data Protection Authorities would also serve as providing guidance in terms of how to actually comply with the data protection, cybersecurity and data protection convention. And we're looking at it from the lens of having something similar to the Article 29 or the European Data Protection Board, so that you have actually a body that is charged with enforcement. So in terms of enforcement, that's why we have the amendment to introduce the Council of Data Protection Authorities.
Thank you very much, sir. Thank you for answering the question. And I should add again, please, if you have questions, please use the Q&A section and your questions will be attended to, or you have comments that you need to be discussed during this panel session. Okay, now to the next question that I have. So for countries who do not have a comprehensive legal framework for data protection rights, and seeing that most countries have a country level data protection regulation or a data protection law to govern data protection in their different countries, and you wouldn't, no country would want to give another country unfettered or unregulated access to data in its country, right? How do we ensure, or how do the African continent, how do we ensure compliance for these African countries who do not have a data protection regulation in their country?
Well, I guess maybe one way would be the adequacy mechanism. I know Nigeria has one, and Nigeria has printed a list of countries where their data, Nigerian data, can flow through easily. So I guess maybe a simple way to do it would be to have an adequacy mechanism introduced as part of enforcement, so that where if you notice that a country has similar regulatory frameworks, then you can allow data to flow. That's what comes to my mind, but I'm curious as to what Temiloluwa would think.
All right, thank you very much, Okwara. Yes, I mean, it's clear, really. I mean, adequacy decisions, would definitely help where, for example, there's no clear legislative instruments in terms of, exporting or effecting a cross-border transfer. Now, just to dive deep a bit, the way it is set up here in Nigeria, I mean, so there are like different layers of, or markers, I would say, different layers of markers. So once, for example, a country does not have, a particular, maybe a specific data privacy law or data protection law. Now, there are some other factors you can look at, for example. I mean, you look at, in terms of, the way the country protects, human rights generally, and what level of, protection do they give human rights? I mean, if they are called, human rights, the same protection that you are called human rights. Now, that's some, sort of, liberty for you in terms of, making an important factor in terms of making an adequacy decision. Recall that I said earlier that, yes, while, we do not have, everyone yet, taking that, bold step in terms of having a specific and a targeted data protection regulation. So when you are able to find a protection in that regard, you look at, the realm of human rights generally and see how they would ordinarily treat, human rights generally. What are the kind of institutions, they have, in terms of their courts, in terms of the law enforcement agencies, generally. So the way, for example, a country would treat, human rights generally would also more or less affect the way they treat, privacy rights also. So where you have, weak enforcement mechanisms, where you have weak investigation, mechanisms and all of that regarding general human rights, likely there's that, possibility that, little or no attention is paid to privacy rights also. So, I mean, the conclusion of that is now, it gives me, I do not have, comfort, as the person making an adequacy decision in Nigeria to ensure that, I'm granting that request, because you do not even have, in terms of infrastructure, necessary to protect human rights. You do not even have that. So where, for example, you do not have laws and, you do not even protect human rights, you don't have institutions that, do protect human rights generally, there's no reason why I would take an adequacy decision in your favor. So where the laws are absent, at least there should be a level of, protection in such countries. So countries that have, weak law enforcement mechanisms for human rights, I mean, they wouldn't have, adequacy decisions, from countries like Nigeria. Thank you.
Thank you so much, Temiloluwa. Thank you, Mr. Elias. Thank you for your response to that question. I have like one more question. So what do you think like are the traits posed by international actors in like Africa's digital space? So where I'm coming from is that I recently read that a study by a digital advocacy group revealed that some subsidiaries of like European countries, let me streamline it a bit. So I read that the subsidiary of an European telecom company operating in Nigeria, which is like the Orange Group, and Vodafone, which are located in Kenya and in Senegal, they kind of granted Africans fewer digital rights than are being granted to their European counterparts. So they have subsidiaries in African countries, but the digital rights being given to the data subjects in African countries are like fewer than what is being given to their European subscribers, their European data subjects. So like, what do you think are the threats that are being posed by, this sort of situations happening, or by such international actors in the African digital space?
Yeah, I mean, part of it, Poikana, has to do with a stark reality, right? And so I've worked in the tech sector in Silicon Valley. I've worked with US-based and European-based companies, and I know they make the decision plainly based on the revenue that comes in, right? So they look at Africa and they say, oh, wait, the amount of revenue that is coming from Africa is so little that they don't even think to pause about the complying with existing mechanisms, because even if they were to be fined, they don't see the fines as being adequate enough to cause them a problem. Because when you look at, for example, the fine for infringing on data protection in my home country of Kenya, they're looking at around 5 million Kenyan shillings, which is about 50,000 US dollars, right? So you can imagine that discrepancy between the fines that are being ushered in Africa and the fines that they have to face with the GDPR, which is a percentage of your turnover. So there's that. There's the questions around economics there that are prevalent. But then there's also just a misunderstanding about the reality in Africa. Like, I was recently very surprised when I met with a major company that is in the security sector, that is in digital security, and they have a very big presence in privacy and data protection in the European and American side of the business. But in Africa, they are non-existent. In fact, they leave it out to the salespeople, right? Sales. And I talk to these salespeople, and the salespeople have no idea what data protection is, right? So I think there's also this dichotomy of the fact that they see Africa is less developed and less, and they just don't put in the resources that are necessary. And I've seen it in practice. I had these conversations as recently as 2 weeks ago. So it's not something that is from a long time ago when we did not have data protection law in Africa. So I think part of it though, so I think what can change it is the coming into force of the Malabo Convention and its subsequent amendment, so that they can see that Africa has a united front in terms of a convention that is encompassing the entire continent of Africa. But then the other aspect of it is around the enforcement. Can we have a united front in terms of enforcement, right? So that we have, for example, the network of African data protection authorities that's headed by the Ghanaian commissioner called Patricia, and it's headquartered, I believe, in Morocco. If we could have a united front in terms of coming in enforcement and saying what you should not be able to do in Kenya is something you should not be able to do in Nigeria because we have similar laws, then that's something that can then send a clear message to folks who are multinational in nature to actually take Africa seriously. But it's a very unfortunate state of affairs.
That's very insightful. Thank you, sir. That's very insightful. Then my last question, so that we're not behind on time. My last question would be, you mentioned, like in your last statement, you mentioned us having like a united front to be able to like enforce this convention when it's being ratified. Now, I want to ask, and Temiloluwa, you can pitch in. Do you think that a separate data or cyber court to handle data breaches and cyber crimes would be more effective? So we just have a separate court which handles matters that has to do with data breaches and all that. Do you think that would be most effective?
I don't know. That's a really good question. So a court of law, right?
Yes, a court of law.
So that's interesting. The question that would beg is, would we have enough sufficient cases to be brought before the court, or would the court be sort of lame in terms of actually receiving these courts? Are we as Africans actively addressing issues that are coming up in terms of compliance with data protection law? I know in Kenya, and I'll give you the example of Kenya. In Kenya, we have the Data Protection Commissioner's Office, and they're currently investigating 47 lending financial institutions, lending digital lenders for infringement of the data protection law. But these are such small issues that are being brought because they're not like the ones that would be massive. And I think maybe to address it would be to make sure that the courts of law are actually trained. Because when I even think about the European side of things and the US side of things, countries that are more advanced in terms of addressing data protection and data privacy, they don't have courts, right? But what happens is that the judiciary, though, is trained on these matters. The law societies are trained and provide training to its members so that they understand that these are pertinent issues they need to be aware of, and so that when they are brought to court, they can be properly adjudicated. But I'll be eager to hear what Temiloluwa thinks.
All right. Thank you very much, Mr. Okwara. So in terms, I think that's a very, very interesting question. I think I also touched on it a bit earlier, right? While I do not, really see the need for special courts in African countries, that's within, national spaces to enforce, some of these, rights that we are talking about, and to see if this will act as an incentive for, greater protection of data privacy rights. I mean, I'm more tilted towards having a continental court. And the reason why I say that is because, yes, I mean, some of the jurisdictions that we are trying to emulate, for example, under the GDPR, they have those courts, that are more or less supranational, where, sometimes disputes, are litigated before them. So, for example, a country like Nigeria now, we do already have, existing jurisprudence, that is, there are, judicial precedents on, data privacy rights already. So there's a whole lot of awareness, and people are actually beginning to approach local courts for, justice. You have Emmanuel Anene and Airtel, Godfrey versus MTN, a number of telecoms, that's Okwara, a number of telecom services and providers have been sued in Nigeria for, things ranging from unsolicited text messaging, and, professional service, firms like, KPMG and the likes, they've also been sued here in Nigeria. And from what I've seen, the decisions, they are quite, decent, right? In terms of, what the law, what the standpoint of the law is. So nationally, within African countries, there might be no need for, specialized courts. But at the continental level, it's really, really important that we have that, so that we will be able to build, because sometimes, when, governments want to make, policy decisions, especially for countries that don't yet have a developed, or their laws are not enforced yet, that's for their national data protection laws, some of the decisions and interpretations of, because we are a law, or a particular convention, for example, or privacy, policies do not have interpretation, because it's neither privacy law is neither here nor there. Sometimes, at the end of the day, it boils down to the interpretation that is given to it by, the data protection authority at the end of the day. So where, for example, the data protection authority takes, a decision, for example, they are regulators and they could be wrong, in terms of maybe balancing the issue of revenue against rights, against fines. So that element of, judicial intervention is actually needed sometimes to provide, a very balanced and a not just legalistic, but also a judicial interpretation to what the law is. And, so that Africa can begin to mirror, the Court of Justice of the European Union, in terms of some of the interpretations, that have come from them, which I think are really, really helpful in, specifying, because privacy laws, conventions, principles at the continental level in Africa would not, as it were, be very, very clear, for example, on every single, matter of privacy. So where those courts come in, that is continental, specialized continental courts come in, is to, put interpretations, for example, things around cookies, what consent means, in, some peculiar circumstances. So it's only those courts that will be able to, really shed light on that. I don't know if I've made this clear. Thank you.
Yes, you have your points are clear. Thank you. We had Dr. Patricia Boshe on the call, but before we move into her presentation, we would like to give Omezaya Alao an opportunity to just give like his remark, and then we move to her presentation. Thank you.
Good afternoon, all. My apologies. I'm not sure how long the meeting had started, because I think I'm still having problem with this time differences. I hope I'm not too late. As Ms. Joseph presented me, my name is Patricia. Yeah, I'm also presenting as in terms of the evolution of data protection in Africa, but in this aspect, I do not have a PowerPoint presentation. And unfortunately, I didn't hear so much about what others have presented, but I'll just go straight speaking of my my perspective and my experience in terms of development. I think I've heard just a little bit about adjudication of privacy and data protection cases, data protection laws in Africa. I've seen some development, especially in South Africa and Nigeria and Ghana, in terms of judicial adjudication of the right to privacy and data protection, but at continental level, that has not been sort of a practice. As we know, I'm not sure if the other presenters have already spoken about it, that also the African Union as a region doesn't, so far up to this moment, the main African human rights instrument doesn't have the right to privacy. And so it follows this lack of the right to privacy to the adjudication. That means since the main instrument does not provide for the right to privacy, it's not logical to expect that the African Human Rights Court will adjudicate on the right to privacy. And so from the upper level, the right to privacy has not been, so to speak, popular. And so when you come to member states, it's again a few countries who have managed to adjudicate on the right to privacy to begin with, and though that will include again Nigeria, Kenya, I think Ghana, and South Africa again. And you can also see the trends in the regional economic courts. For example, the SADC tribunal had tried, so to speak, to deal with human rights cases, but at some point it was stripped of its powers to deal or to adjudicate on human rights aspects. That was after the case of, if you might recall, Zimbabwe had a case that touches into human rights, the right to own land and things like that. And after that case, the controversy that came out of that case led to member states stripping it of its powers to adjudicate on human rights. And so it's not very popular in this context. And so when we speak of data protection in Africa, we've come a long way, and we still have a long way to go. And I think, as the previous speaker said, while we develop our own frameworks, we develop our own precedents, it is also important to look at what others are doing. For example, our precedents from let's say European Union, where we see a lot of cases from different countries in EU. We can learn, we can watch, we can observe and see how data protection is dealt there. What are the developments there? And how can we improve our, let's say, policy making, decision making, adjudication of data protection and right to privacy based on the experience of others. You could see, for example, if I move from case to case adjudication, if you look into policy making in African Union, you can see that African Union as a region has already been doing that in terms of policy, the policy development and regulation. When you look at the African Union data policy framework, you will see that this framework is a bit, you can say it's a step forward. Many policies, even from the Western, it speaks of things that I would say they are pioneering aspect in data protection and regulation of the digital space. For example, one of the things that the framework is proposing or is recommending is that, for example, data protection authorities should not be operating in isolation. That is something that, for example, I believe African Union and its member states have seen what is happening in Europe, have learned from the other developed countries, and see the importance of having data protection authorities working together with other data-related authority, for example, competition authority, consumer protection authority, intellectual property authorities. One of the main problems that had emerged in Europe is that it becomes very difficult to protect personal data, for example, when there is a merger or an acquisition of big companies that are data related. And the question that was of a controversy, like I think 2 years back, was that during merger and acquisition of big companies that deals with data, for example, and during the process, how does a competition authority, because competition authority will be there to look and analyze whether there are no competition laws that are not breached in terms of measuring and acquisition, but who or what authority will be there to look at the rights and protect data of individuals involved in these processes? And that had brought a lot of controversy. I think it was a case of when Facebook was measuring. A lot of e-personal data were involved in this process. The competition authority was involved because these are it's a big company. It was measuring, but a competition authority was there to assess a competitive or to regulate that Facebook does not take monopoly of the space. But there was no involvement of the Data Protection Authority to look or to regulate the protection of personal information. But up to this moment, despite the fact that these controversies and questions arose, in Europe, we do not see trends, we do not see sort of development in measuring between these two authorities in terms of protection of personal data. But in Africa, we've seen that in the EU data policy framework that proposes that there is a need, and countries, member states of African Union should make sure or should support systems that allows, for example, data protection authorities to work together with a competition authority Consumer Protection and Intellectual Property Authority to allow that not only that we protect personal information, but also as we moved into a digitalized world, we are able to do a digital economy. We are able to do e-commerce in a way that not only that we focus on protecting consumer, but all the 3 or 4 areas where personal data is involved has a specific regulation or a specific oversight to make sure that personal data is protected, intellectual property rights are looked after, consumers are protected. And I think this is a when I look at the African Union Data Policy Framework, I think it's a visionary document that brings Africa into data regulation sphere as a strong partner that can now being able to say we have a vision, and we request or we demand to have sort of a place at the table when big nations or Western countries are discussing regulations and policies relating to personal data. I think it's high time for Africa to also speak and say, we also have, we demand, as I said, we demand a space to speak, but we also have something to contribute to this space. I think that's from me for now, and hopefully I was able to capture things that were not spoken and not repeating what was spoken before.
Thank you very much, Doctor. Thank you for your presentation. So we're just about to close out on the panel discussion before you joined in. So I'm just going to ask you this one question, which I have already asked the other panel members, and then I just want to get your points and views before we close out and move to other items on the agenda. So my question for you now is, right, what would you say are the major barriers to effective implementation of data protection regime in the African continent? So, like, what would be your recommendations for such implementations, and which you think would help, strengthen the data protection? Will help strengthen data protection in the African continent? Yeah, thank you.
I think the main challenge that it sounds like a cliche because it's something that comes up in every conference, in every symposium that I'm taking part in, is the fact that there is a strong and urgent need of data protection authorities to work together. Africa is a country of 54 countries, members of African Union, and at the moment, I think there are about 35 countries with data protection, but we do not see, we see development in policies and regulations, but we do not see so much, or maybe we do not hear so much about collaboration between these agencies. And these agencies are the ones who are sort of tasked or are guardians of individual personal information. And the only way to be able to enforce data protection within countries and beyond borders is for these authorities to work together. They cannot work in isolation. I think that's the main challenge at the moment. And that also brings another problem, because if each authority is working within their countries and there's no strong cooperation with others, that means there's a possibility that laws, although the basic values speaks the same language, there are some aspects that they may vary from one country to the other, and that brings Africa continent and countries within African continent a step behind, or a step behind harmonization, and harmonization being one of the central aspect, one of the most important aspect in terms of data protection and especially data flows. So I think the main challenge at the moment is cooperation and working together between African data protection authorities from different countries.
So, what would you think are the best ways to, like, what would you think would be the best ways to implement, to like strengthen data protection in the African continent? What are your recommendations?
Well, we already have the African Network for Data Protection Authorities. I think the first step is to start from there, to recognize its role as a network that is intended to bring together data protection authorities in Africa, to recognize its role and to sort of give it's visible, it's there, but sort of try to give it a push to start to keep on or to not to start, but to keep it rolling. It started, I think, in 2017 or something, but it's not so much. We haven't seen so much coming from this network. So I believe is to promote its existence, to promote the work that it was established to do. It's the place where I believe the coordination and the working together between African Data Protection Authority can start. From this network, it's easier to bring together all the African Data Protection Authority and speak the same language, to regulate things that are not in harmony within, because we know not every law look the same within African countries. So there's also a few aspects that maybe need to be brought into harmony. This network can be able to do that. There's also the role of African Union, but we also know that African Union, just like this network and different from the EU organs, does not have enforcement powers in terms of the data protection. It only has powers to make policies, rules, regulation, and recommend that member states to adopt them, but does not have power to enforce them. Like, for example, if you take an example of the EU, where when the GDPR came into force, countries were given 2 years to make sure that they abide. That's not the case in Africa, unfortunately. So it's very difficult to say that we have this framework, it has to be taken into account. And when a country does not take it into account, it can face sanctions. That's not the case. And so we need to be more proactive than the rest of the world, I think, because we do not have an organ that's behind us that can be able to sort of sanction those countries which do not abide or form such protective frameworks.
Thank you. Thank you so much, ma'am. So we just hope that with the ratification of the African Union Convention on Cybersecurity and Personal Data Protection, that's the Malabo Convention, when it's eventually ratified and by the member states, we can, like Mr. Elias mentioned, we can like amend it, and then we're able to enforce it as within the member states and as a continent. Thank you so much for your presentation, Ma. Thank you for your time, so that we are not like way behind on time. We'll move to the next item on the agenda, which is to give, we have to give Mr. Umezie Alao an opportunity to make his remark, and then we'll head over to the announcements of the winners for the essay competition. Thank you all panel members. Thank you. Thank you for an insightful conversation today. Yeah, I have like a great and pleasant day. Let's just go into the next item on the agenda. The banking.
Good afternoon, everyone. This is Omeza Alao. Firstly, I would like to thank all the panelists for their insightful thoughts shared during the presentation. It's particularly pleasing to see that data protection awareness is continuously growing in our community. And I'm even more pleased by the fact that the discussion is going beyond Nigeria and also involving the general African community. I was particularly interested in all the discussions. I remember the discussion about the discrepancy between the data protection afforded to multinationals in their home country when compared to that offered to their subsidiaries in Africa. It's actually an issue I recently had to struggle with. But generally, I am very thankful to the panelists. Thank you to everyone present here. I am pretty sure my brother would continuously be proud of the fact that we are keeping his passion and love for data protection alive. Thank you very much.
Thank you, Omeiza. I hope I pronounced your name correctly. Thank you.
Don't worry, you eventually get.
Yes, thank you. So the next item on the agenda is the announcement of winners for the law students category. This will be done by Toby. And also we have announcements of winners for the young lawyers category for the essay competition. So we'll just move into Toby.
Okay, good afternoon, everyone. I'm very grateful to everyone who has been able to join us. Thank you, especially to our panelists for taking time out of their busy schedule to be with us and to share from their reservoir of knowledge on the subject. We're also here to reward those who participated in the essay competition, and I have the privilege of announcing the winners for the law students category. I imagine if this were an in-person event, this is where the DJ will be playing the champion song. But so just imagine that you're hearing something like that in the background whilst I announce the winners for the law students category. So coming second runner-up, we have Abdul Pelumi Ganil from University of Ilorin. I hope Abdul is here. Then the first runner-up is Oluwadamikwe Princess Adedeji. I imagine that's a lady, and I'm very glad that we have women winning this particular category because the first prize winner for the law students category is also a lady. That's Olani or Mary Omobolanle from the University of Ilorin. So University of Ilorin has produced two winners in this category, and I'm very happy that two of those winners in this category are ladies, one from Obafemi Awolowo University and the other from University of Ilorin. Olani or Mary Omobolanle will be given the opportunity to talk us through our essay later on. But for now, I will yield the floor to Deji Sarumi, co-founder of Tech Hive Advisory, to announce the winners for the Young Lawyers category. Tech Hive is one of the sponsors for the essay competition. Thank you.
Thank you very much, Toby. Good day, everyone. And I'd say congratulations in advance to the winners and runner-up of the competition. It was a tight one this year, I believe. So I'll start with the second runner-up. We have Alao Mustafa Tolani, and the second runner-up. Then the first runner-up is Ayodeji, Ayodele, Ayolola. And then the winner of the Young Lawyers category is Gabriel Temiloluwa Omoni. So very big congratulations to the winners of the two categories. Yes, I think the winner here, Gabriel Temiloluwa, would also be allowed to make a few comments before the end of the program as well, and they would be contacted as well in due course. So congratulations once again to the winners and the runner-ups, and thank you for participating in the program. Back to you, Banke.
Okay, thank you very much, Toby and Deji. I am trying to find the winners on the call. I'm not sure they're here currently. So, okay, I found Gabriel Omon. So, okay, just give me a second to. Okay. Gabriela Money, you have the floor. Just make it brief. Walk us through your essay briefly, please.
Okay.
Thank you.
Good morning, everyone. Yeah, it's I'm very happy to be able to make this presentation. And my presentation basically is on the African Union 2063 agenda and data protection. Now, I started the essay by basically looking at and making a comparison between the European Union, the provisions that did the data protection, that's the General Data Protection Regulation, which entered into force in 2016, but only became applicable in 2018. Now, basically, what the GDPR does is that considering how the EU operates, in the sense that once it's a regulation, it's directly applicable to all the member states. So there was wide acceptance about how the GDPR was going to regulate data protection in the EU. But now coming to Africa, Africa is still lagging behind. There are still a number of member states which do not have data protection regulation. And just like as it has been highlighted by some of the panelists, we see that even it appears as if there is no unity among the institutions, or maybe we are not hearing enough, just like Dr. Patricia did say. And so we realize that data protection is not really a front burner issue. And even looking at the convention that was entered into, realize that just only a few countries, 30 members states of the 53 countries, based on my research, are those that only ratify the African Union Convention on Cybersecurity and Personal Data Protection. So we see that data protection is a topical issue, something that needs to be given a front seat when it comes to Africa. And African Union 2063 agenda, it's a very good initiative. It seems to put Africa ahead. It seems to put the people ahead. And since we are in the fourth industrial revolution, whereby whereby ICT is the main thing, coupled with the ICT is data gathering. And if there must be data gathering, then there must be data protection. And I think this is where data protection comes in. So I believe that there are a lot of other policy documents that have equally been issued by the EU, maybe by themselves, or maybe in conjunction with some organizations, or maybe some intergovernmental organizations that people issued some policies. But the issue with most of these policies is that there is no direct application. Like, they are not laws per se. They are just basically guidelines. They are just basically frameworks which do not have a legal framework in Africa. And so I think Africa needs to wake up, and I appreciate the EU for talking about the 2063 agenda. But I believe that there is much that can still be done. We can look at the EU and look at, of course, we do not have the system like the EU, whereby there's a direct application of their laws. But at the same time, too, I think we can do more than we are doing right now by making sure that we have laws that are put in place. I think these are some of the issues that we need to do. And just as it has been highlighted, I think the Convention on Cybersecurity and Personal Data Protection in Africa, while writing this essay, I realized that even the rights do not, when you compare it side by side with the GDPR, it does not have that provision, like an exhaustive provision that can guarantee data protection. So I think maybe the convention, just like Dr. Patricia has equally said, maybe the convention should be amended, or maybe there's a protocol, and then the member states should accede to this convention, ratify it, make it applicable, have proper institutions in their member states that can protect data protection in Africa. And I equally think it's also going to help the intra-African trade that we are trying to achieve. African as a whole, we have a great huge potential, looking at the members, looking at everybody, looking at the population, but I believe that we are not tapping the needed resources optimally. And I think we need to give data protection in place, because definitely it's going to drive a lot of investment in Africa. It's good because, as I said, data protection is, data gathering is needed, and data gathering is equally essential for technological development. And if there's no data protection, there can't be data gathering. And if there's no data gathering, then there can be improvements in ICT. And we all know that if there's no improvement in ICT, then there is no increased development for Africa. So I think Africa needs to arise, and based on the conversations that have been said over time during this symposium, I think there's still more that's, of course, something has been done. We can't deny that fact, but I think more can still be done. And I think with all these things, data protection is quite a very solid one. And I think you can work more and improve data protection in Africa generally. So the 2060 African Union agenda is a very good one. It looks far, right? But at the same time, too, I think we need to start something now. If we'll be able to achieve the agenda that is set, the aspirations that is set in the agenda. So I appreciate the organizers of this program for giving me the privilege to be able to just talk through my essay, and it's been a wonderful one. And I equally appreciate all my co-winners, and I wish everyone the best in their careers. Thank you very much.
Thank you, Gabriel. Well, I'm not sure Mary Olaniyan is on the call to give her remarks. So in the absence of that, I would move to Toby Adebowale, the co-founder of Loyad, to give his closing remarks. Thank you, everyone, for joining us this morning.
Okay, thank you, Banke. So in wrapping up, I must express my gratitude to everyone, starting with Adavize's mom. She's a mother to us all. We really thank you, Ma, for always finding the strength to join us every time we host this event. We're very grateful for the strength that you show. Your strength also encourages us to keep on doing this in his honor. We thank you for always finding time to be with us. I also want to thank Omeza, Adavize's brother, who has always supported us in terms of keeping the brand running and in making sure this event is a success. I particularly want to thank our panelists, Mr. Elias Okwara, Dr. Patricia Boshe, and Temiloluwa Dosumu, as well as Mpoikana Joseph, who moderated the panel session. What many may not know is that Mpoikana is as well a former winner of the competition. She won the 2020 edition, the Young Lawyers category, and I'm happy to see her thriving in her career. She's a legal associate at Carbon, one of the foremost digital banks in Nigeria. And the way she has masterly handled the panel session today shows that we've perhaps, to claim some credit, set her on the right path as far as the topic of discussion is concerned. So I'm very grateful to everyone for helping us all to dig deeper into the topic of data protection and its evolution in Africa. And we really cannot thank you enough. And we hope that when we host this on a larger scale and we call upon you, that you would also oblige us and participate in the event. I also want to thank everyone who has supported the essay competition and the symposium, all our sponsors and partners, Tech Advisory, Ikigai, Duale, Obi, and Alex Adedipe Law Firm, where Adavize worked, Fansview Solicitors, who came on board as sponsors this year and contributed immensely to the prize money for the law students category. Sultan, one of Adavize's friends, was been reaching out. Taiwo Akini, one of Adavize's friends, was always constantly supported financially and in every other way. I also want to thank every other person who's contributed but asked to remain anonymous in terms of sponsorship. we cannot thank you enough. It's because of your support that we're able to continue to do this. Now, I also really like to thank every member of the lawyer team who worked together to put this together, and others who were not particularly members of the lawyer team, but friends of the house and Adavize's friends. Your names are too numerous to mention, so I would not like to keep us all on the call for longer than desired. But from the depth of my heart and on behalf of the lawyer team, we say a very big thank you. To everyone who has participated in today's event, attendees, panelists, I mean, we're able to speak because we know that we have an audience. And so without you, this event would not have been. I cannot thank you enough. We express our heartfelt appreciation, and we hope that when we call upon you again in the near future, you oblige us. So in saying goodbye, I would like to say we have a commitment to keep this going, and we hope that the 5th edition would perhaps be bigger than this, and we'll be able to attract more participants from across the continent, and also be able to host us perhaps to an in-person event if the circumstances permit. Thank you all for supporting. Thank you all for attending, and we hope to see you sometime soon.
All right, bye everyone. Thank you.